How to ensure Mini-WARN Act compliance during layoffs. Imagine planning a big change at your company and suddenly realizing you might be missing important legal steps. That's where understanding Mini-WARN Acts becomes essential. These laws are designed to protect employees when layoffs happen, especially in smaller companies. Knowing how to follow them can save you from costly penalties and legal trouble. First, you need to check if your company is covered by the Mini-WARN law in your state. Many states set a threshold of 50 or more full-time employees. Some states also count part-time workers or remote employees when calculating employee numbers. It's important to verify your total employee count using the state's specific rules. Next, understand what events trigger Mini-WARN requirements. Usually, these laws requiring notice if you plan a mass layoff at a single location affecting a certain number of employees, often 25 or 50, or if a percentage of your workforce, like 33%, is impacted. Plant closures, whether temporary or permanent, also trigger notice obligations. Additionally, significant reductions in hours for a group of employees over a period may require notice. Providing proper notice within the right timeframe is crucial. Unlike the Federal WARN Act, which mandates 60 days notice, some states requiring 90 days notice in places like New York, Maine, and New Jersey. Washington State, for example, requires 60 days. Notices must be given to affected employees or their representatives, such as unions, and also to relevant government agencies or workforce offices. Your notices should include key details. Clearly state why the layoffs or closures are happening, the exact date they will occur, how many employees are affected, and their job titles. It's also helpful to include information about employee rights and any assistance programs available. Monitoring the timing of layoffs is important because multiple smaller layoffs within a short period may be combined for notice purposes. Employers need to track layoffs carefully over a period, often 30 or 90 days, to see if the total triggers the law. Exceptions exist for unforeseen circumstances like natural disasters or sudden business crises. These may excuse you from providing notice, but you need solid documentation to support any claims. Because laws vary by state and can be stricter than federal rules, consulting with legal counsel is a wise move. They can confirm whether your company is covered, help craft compliant notices, and advise on any exceptions or defenses. Finally, keep detailed records of all employee counts, notices sent, and communications with employees and government agencies. Good documentation helps demonstrate your compliance and reduces legal risks. In short, ensuring Mini-WARN Act compliance during layoffs means knowing your state's specific rules, providing timely and detailed notices, understanding exceptions, and working with legal experts. Staying informed and prepared can make the process smoother and protect your company from penalties.